after an indictment or information is issued. Next comes the felony arraignment. During the felony arraignment process, the defendant is forced to appear in court in front of a judge to enter a plea. The defendant can plead guilty, in which the judge will set a date for sentencing. If the defendant does not plead guilty, they will set a trial date and decide whether or not the trial will be by bench trial or trial by jury. Bench trial is when there is no jury and the decision is decided by the judge. The other option is trial by jury, when members of the public are chosen to listen to the case and make a decision. Another option is to plead no contender or no contest, in which the defense does not admit guilt but does not contest the charges. The benefit of this is that the charges cannot be brought up in civil cases later. After the plea, there is no trial and it goes straight to sentencing.
Are charged with a federal offense, they have a right to appear in front of a judge and be provided with notice of what they're being charged with. So that is what an arraignment is. It's a period of time where the defendant gets notice as to what the criminal charge is. So many times you will hear a defendant through his attorney say, we waive reading of the charge, we enter a plea of not guilty, and request a trial date. So what that means is, by waiving reading means I don't want the document that charges me to be read out loud. I've read it and I've understood it. Not guilty is a type of plea that can be entered, and then the trial date is a request for trial date. So what a judge will do at an initial appearance or an arraignment is set the trial date and all other dates that will be in force for purposes of preparing for that trial. So for example, the judge will give you your trial date, the judge will give you when motions are due, when the government has to reply to motions, and when the court will have what we call a final pretrial conference. And that's the day you have to give notice to the court about whether your client's going to plead or go to trial.
Okay.
So basically it's just a housekeeping matter as far as trial dates and all of that. Many times, I've never had a client that's ever asked that the charge be read. So what the job of the defense attorney would be prior to the hearing is to go over the charge with the client, explain to the client what the charge is, and make sure the client understands it before you go into the court and bring a case. One is indictment, which means that the grand jury reviewed the case and made a determination of whether there was probable cause. And another is by way of information, and it's a document that's created by the government that the defendant agrees to being charged via that document, and waiving his right to be charged by the grand jury. A lot of times, if the government is investigating an individual, they can tell that individual, you're under investigation and we're potentially going to charge you with X, Y, and Z. That person can get an attorney, and then through the attorney can work with the government in reviewing evidence or making a determination. And so sometimes the case gets resolved, or they've reached some kind of negotiated plea, and then they would come into court, and at the initial court appearance, they would plead guilty to the felony information. But if there is no such bargaining or negotiation done prior to, I would never advise a client to plead guilty at an interview.
Next, the pretrial motions occur. A motion is a formal request for the court to make a ruling or take some kind of action. The defendant can file a motion to have a case dismissed, to look at the evidence that the state has, set a new trial date, attempt to not allow certain evidence, or change the location of the trial.
Not necessarily, because if the government finds out that we have certain things, or they could file a motion as well. Most times, though, I'd say 90% of the time, the pretrial motions are by way of the defense. So they normally set the trial date 70 days from the date of arraignment, but most trials don't go within that 70-day period. You can ask for extensions of time for various different reasons. Most times that you need more time to investigate or research legal issues. And so I'd say most trials resolve with a criminal case is resolved with a plea or a trial within maybe 6 months to a year from when.
And the last step that we will cover is the trial. Now, the trial happens right after the felony arraignment and the pretrial motions. Before the trial, however, there is a process called voir dire, in which jurors are chosen from the public. Each side gets to interview the prospective jurors and eliminate some for cause if, for example, the person knows the victim, and a limited amount of preemptory challenges, which means that there is no way that this person would be favorable to the side that you are on, so you can get rid of them. However, you cannot get rid of a juror based on discrimination, for example, race or gender. After this, the trial begins. The prosecution, represented by the state in a crime, is sitting closest to the jury because they have the burden of proof. This means that the prosecution has the job of proving that the defendant is guilty, as the defense is presumed innocent unless there is enough evidence that can convict him. All the witnesses from each side are heard and questioned from both the prosecution and defense. After all the evidence is laid out and the jury has heard both sides, there is jury instruction.
So what happens is the government has a certain charge which they have to prove. There's elements to that charge. And like, for example, in a bank robbery, the charge is that a person entered into a bank within the District of Hawaii and took from the bank money that was in control of the bank by the use of threats, force, or coercion. And the bank is federally insured. So the government has to prove all of those evidence or all of those elements before a jury can find a defendant guilty of a bank robbery. So what jury instructions are is they, number one, lay out what every single element is, and they also lay out what are definitions of terms that are used. But you can also submit instructions for the jury's consideration on, for example, the fact that the defendant doesn't have to testify. The fact that even if a government agent testifies, their testimony is not to be given more weight than any other witness that comes and testifies. It provides instructions to the jury as far as what is the different types of evidence that can be received. You can receive direct evidence, somebody who personally saw something, who was involved in the interaction, or you can receive circumstantial evidence that here's one fact and here's another fact, and you can make inferences based upon the two facts. Okay. Those instructions explain all of those things to the jury and what is proper for the jury to look at. There's also instructions about how the jury can't do their own independent research, how they're bound by the evidence that they receive within the courtroom. It talks about their obligation and roles as jurors once they get into the jury room, and how they're supposed to act and conduct themselves. So it's basically how to be a juror, how to make a determination based upon the facts and circumstances of the case. And then if there is other things that they have to decide, like in a criminal case, sometimes the jury is asked to decide specific things in regards